So hello everyone, and welcome once again to this panel on increasing slavery regulations, and in particular creating a global standard from the UK Modern Slavery Act to Australia. So just by way of an intro, I mean, the last years have marked a shift from the ethical to the accountable. We've seen a real shift from fluffy CSR activities to a real sort of climate of accountability, with people stepping up and with a lot more regulations coming into play. There has been an array of legislation. In fact, can barely keep up with everything that's going on. Starting, quite a while back with Brazil and some of the pioneering work done in Brazil by the government in partnership with the corporate sector. There was, of course, the California Transparency Act, the Modern Slavery Act, and in between in the US, there was, of course, the Obama Executive Order and many other measures. The most recent one being the hotly debated Modern Slavery Act in Australia. And a lot of the focus areas of these acts have tended to vary slightly, with the Modern Slavery Act in the UK focusing very much on transparency. And when one looks at the European bills that have gone through, and some of which are still in the process, such as the Swiss bill, a real sort of focus on accountability and enforcement of vulnerable individuals' rights. So I'm told we don't have time for me to properly introduce the panel because your job titles have already been shared with people, but feel free to look at the Convene app. And I want to start straight away, Michael, if I can dive into with you. The Modern Slavery Act, what sort of a standard does it set, and what ground is it really covering?
Maybe it's easier to start with the ground that it's covering. Looking at where the Modern Slavery Act came from, which its origins are clearly based in the California Act, the way in which the Modern Slavery Act is so original, not just for the UK, but as a bellwether for where we're going globally, is that it has a very significant extraterritorial effect. Companies with any kind of business presence in the UK, assuming they meet the other requirements of the Act, are going to have to provide a statement as to modern slavery and human trafficking in their business and supply chains, which, if you think about it, has I think the estimate was 17,000 companies would be caught by that. And of course, if you're sitting in the UK rather than here today, you'd be thinking about pretty much every provider of goods and services that you could think of. So the breadth is significant, and this obviously follows on from there being no law of any kind to cover supply chain analysis prior to 2015. So the breadth is significant. What it means for companies, it means a significant outlay of resources to ensure that they can provide the sort of statement that the Act is asking for. It should be clear that the Act has the quirk that you can provide either a statement as to steps that you've been taking over the course of the previous financial year, or that you have taken zero.
A quirk is a very diplomatic way of putting it.
I always wanted to be a diplomat, but I'm a lawyer instead. So
it keeps you in business, I suppose.
So I read from the black and white paper. Of course, that's been hit upon. We've discussed it at length, how this is the ultimate get-out. I think in reality, and the rest of the panel will be aware of a number of slavery statements that are out there and can chip in. What we're seeing is no companies deciding to take the opt-out route. No one wants to be that person making a statement saying, we've done next to nothing, and we apologise for that. So what it does mean is companies engaging in their supply chains internally and with other stakeholders to produce something that is increasingly of worth. I think one point I would make, we're coming to the end of the first round, as it were, and only just are we beginning the second round, because one of these statements has to be produced annually. And it would be interesting to see what we build on in the second round if these statements that are produced in financial year 2 that are covered by the Act build on what was promised in year 1.
Okay, so tell me this then, are we talking about a human rights due diligence process, or are we talking about a human rights risk-focused due diligence process. Do you see that in the Act?
So, going back to the word of the Act, putting my lawyer's cap on, there is a heavy hint that companies should be undertaking diligence. It's even covered in Section 54 of the Modern Slavery Act, but it is presented, interestingly for legislation, it's presented as a suggestion that you may want to talk about the diligence that you've undertaken in the year. There is that ultimate caveat that you can do no diligence and you can announce the fact. And as long as you have a director of the company or a partner of the partnership sign that statement and make it available to the public, either on a website or available on request, then you will meet the requirements of the Act. So I think we have hit upon, when we've had discussions about this previously between you and me, that there is a disjuncture between the spirit of the law and the black letter of it. But the reassuring thing from our experience is that people are going beyond the black letter. They are going into areas of diligence that they haven't previously considered. Some companies are asking, how do we do human rights due diligence? Can you assist us? And how do we present that in the form of a statement? So the story is not all bad. In fact, in some respects, it's a quite uplifting one. It's great to hear that companies are engaging with human rights due diligence, sometimes for the first time, sometimes in the instance they don't have unlimited resources to do so. And in that respect, we have more than we could have expected.
So Jelita, is your story as uplifting, and what's been your experience?
I'm worried about being a bit too positive, actually. I have to say we've certainly advised primarily through our London office, naturally, given the origin of this legislation, dozens of clients on the issues associated with producing their statements and complying with the Act. One of the, perhaps maybe to balance it a little bit, I'd say, one of the comments that I've had from our team in London who work in this area is that perhaps the candidates you expect to want to do the right thing do want to do the right thing around this legislation. But I also think that we have seen instances, many of them, of companies for the first time, as you said, Michael, looking into this issue more deeply. And I would say as a firm as well, I mean, we of course are ourselves covered by the Act and have made our own statements in respect of compliance with the Modern Slavery Act, have done more engagement as a result of this legislation than we have ever done before, in a more, I think, rigorous way, turning the mirror on ourselves and saying it's not good enough for us to be advocates for this issue without also knowing that our own house is in order. So what are some of the clients asking us to help them with? You may be surprised to know that fewer of the inquiries are in fact about discoveries of slavery. That's a good thing, but obviously at the same time we want that diligence to be rigorous, and we are working with our clients to improve that. Predominantly the questions are around whether or not the Act applies to a particular organisation. As Michael's indicated, the extraterritorial impact insofar as it captures businesses who have some business conducted through the UK as opposed to simply being incorporated in the UK, and because businesses have to report on their own receipt of goods and services, means that there will be significant cross-border connections. And we've had a number of clients who are interested in reporting voluntarily, so they themselves are not convinced or through advice it's not clear that they fall within the scope of the Act, but they're nevertheless minded to make a report because they operate in the UK market, and alongside their peers they need to be seen to be taking this issue very seriously, and as I say, having looked within their own house and then being able to speak publicly about what that has resulted in. I think the second area that we give most of our advice on, of course, is the scope of the statement. Have we done enough? Does it say enough? Have we looked far enough? How much further do I need to go? Which countries do I need to worry about? Am I taking an appropriate risk-based assessment, etc.? And as Michael says, the truth is that the Act does not have any minimum requirements as far as what a company needs to say, but then we all know from a reputational perspective that corporates of this size that are caught by the revenue thresholds within the Act have a reputation to uphold, and so they're going to be looking to do what their peers are doing. Unfortunately, that's a higher common denominator in most cases than a lower common denominator in this area, I think, because of the attention that is now on modern slavery as an issue more broadly. And then finally, one that made me giggle actually when I was speaking to my team about what they've been looking at. They get a lot of questions about the formal requirements as to who has to approve it, who has to sign it, whose name has to go on the website, and where the link has to be on the page, because there's a requirement to place a link to the statement has to go on the homepage of the website of the relevant company. And as I say, at first I thought those were slightly amusing concerns for clients to have after you've already gone through the issue of looking at whether or not you may have some slavery in your supply chain. But actually, I think they're quite critical issues as far as the impact of the Modern Slavery Act is concerned, because this is an issue that now goes to the board level. Previously, it could have maybe been in the back corner, as you say, of the fluffy CSR program. But now it is something that people very senior in the organisation, right at the centre of the company, need to give attention to and need to sign off on and have their name associated with publicly. So that is a legitimate concern, and I think it's a strong element of the impact of the Act, even if from a sort of technical perspective, actually there's some quite minimal, de minimis type requirements in terms of compliance.
Thanks, Jelita. Lowell, can you perhaps comment a little bit, because I know the Business and Human Rights Resource Centre runs the Modern Slavery Register, and you obviously collate a lot of these submissions and you analyse them, run trends, etc. through them. What are you observing from the first round of submissions?
Right, so just to introduce a little bit about our registry, we spent quite a lot of effort to maintain this free public track record of companies that are giving statements answering this UK Modern Slavery Act. And currently the registry has more than 2,800 statements from companies from all over the world, from 26 sectors and 34 countries, including Hong Kong and China. So our users can go onto this registry and look at what the companies say they are doing to eradicate modern slavery in their operations and supply chain. You can search according to the sectors, companies' names, and the countries where they are headquartered. Companies can also submit their statements onto the registry, and you can download all the statements within one click. So according to our observations, well, we have now got more than 2,800 statements on the registry, and there are literally no company, as Michael mentioned, there are no companies saying that we are doing nothing on modern slavery. But there's chances are they can either do nothing and they don't disclose it, or they can do nothing and publish statements that makes them appear to be doing something. So we see that there are small clusters of companies that are being leaders in this area. There are companies that are demonstrating strong commitments to this cause. But there's a far longer list of companies that are publishing weaker statements, that are producing very little information on the 6 key areas that the Modern Slavery Act is requiring, on supply chain, policy, due diligence, risk management, effectiveness, and training. Nevertheless, as our fellow panelists have mentioned, it's really starting conversations within companies as well as between companies and different stakeholders to really help the companies to understand these issues, as well as start to collaborate with different partners to eradicate modern slavery in their operations and supply chain. Just to give a couple of examples from our observations, one of the weaker statements from a Hong Kong headquartered company that I'm not going to name, it has 4 lines in the statement. It says, quote, "We have in place processes to identify and assess potential risk areas in supply chain, mitigate the risk of slavery and human trafficking, monitor potential risk areas in our supply chains, and protect whistleblowers." And that's the end of their statements. For some stronger statements, particularly on the area of supply chains, for example, Burberry, they publish the the locations of their suppliers by region, and they have extensive details about structure and complexity of their supply chains by company divisions. In terms of due diligence, Marks and Spencer's, they have internal governance structure on modern slavery and human rights active at both operational and leadership levels. So these different departments the department heads are actually responsible for the compliance in their respective departments and for their suppliers' relationships. On effectiveness, which is one of the other key areas, SAB Miller, the British brewing company, they actually disclose the risks identified through their audits. They detail their action plans and demonstrate that these findings inform their business decisions. This is usually the kind of information that companies say that are like business secrets, but there are some companies that are stepping forward and say that, okay, I'm going to disclose all this information. So just to give some examples about the spectrum that companies who are leaders in these areas, and also some of the laggards.
Thank you, Lowell. Jennifer, now a day hasn't gone by in the last month where we haven't seen announcements come out of Australia about the Bali process, about your Modern Slavery Act, etc. And by and large, you're looking to emulate the Modern Slavery Act in the UK. And I just wonder if you could offer a bit of color on what's been going on in the discussions that have taken place, but also have the discussions in Australia referred in any way to the European models that are out there and that are a lot more, let's say, have a lot more teeth than the Modern Slavery Act UK?
Well, thank you. The whole thing is such an experiment, isn't it? The Modern Slavery Act is still quite new, 2015. At the same time, we're looking at what's happening in Europe and the approach to adopt due diligence measures there. Australia has become entranced with the Modern Slavery Act. We have our discussion and our debate and our thinking has gone back to England to look at. It's very ironic. I know. To look at what the English are doing. And but it is, I think it's something about the name, the Modern Slavery Act. It's very clear. It makes a statement. There are provisions in the Act that are attractive and which could be of great utility within the Australian context, particularly the provision that would establish an anti-slavery commissioner. Thinking about the Section 54 Modern Slavery Act provisions, it's clear that they are, you will have to forgive me, but it's clear that they are ineffective. But at the same time, I realise that they're very new and it's still in the experimental stage. There is no effective enforcement. There is no central repository requirement. There is no oversight. We don't know how many companies should report, and we don't know how many have reported. There are huge holes in the scheme that are set out in Section 54. The split between the mandatory provision and the discretionary is unclear, and you've said that some companies are happily addressing the discretionary options. So there are huge questions for us about the effectiveness of the UK Modern Slavery Act, transparency in supply chain provisions, and yet it is the model that is dominating our thinking. In fact, we have a parliamentary inquiry specifically convened to look at whether Australia should adopt a Modern Slavery Act, just like the one that they have in the UK. I'm sorry about my voice. So that is a parliamentary inquiry that has just issued an interim report. They issued that interim report in preparation for the Bali process, and we heard about that earlier today when Kimberly spoke. But this is another key development in the Australian context, the Bali Regional Business Forum, where representatives from over 45 countries, government and business, agreed to establish a work plan to look at addressing transparency in supply chains in the Indo-Pacific region. That is a huge development, one that's absolutely critical. But then there's something else that I want to speak about before I have to stop.
Go for it.
Which is, this is really important, and I want to ask you what you think, and this is a sincere question to you. So the Minister for Justice, Michael Keenan, has issued a very important consultation paper on the issue of transparency in supply chains. It's only a week and a half old, and we're asked to make submissions by the 20th of October. In this discussion paper issued by Minister Keenan, representing the Attorney General's Department, he has set out a scheme that could apply within the Australian context, and he's asking for advice and recommendations about the operation of that particular scheme. So we have said in this paper, we being the Australian government, not me, that companies likely to be required to produce a statement if legislation is developed would be companies over 100 million Australian dollars global income each year. That the requirements would apply to all entities headquartered in Australia and entities who have business operations in Australia, providing that they meet the financial threshold. And then interestingly, what the Australian Attorney General's Department, Minister Keenan, does has to address both the UK compulsory and the discretionary obligations and combine them, and to say that in the Australian context, the proposal is for entities to report on annually their structure, operations and in supply chains, any risks, modern slavery risks in the entity's operations, policies, processes, training, code of conduct, supplier code of conduct. These policies and procedures are also to be reported on. And importantly, the entity's due diligence processes relating to modern slavery. That's an important clause within this discussion paper, and it's one that I think that I hope that organisations who respond to Minister Keenan will take up in their submissions. And arguably, a reference to an entity's due diligence processes can be interpreted within the context and the language of the UN Guiding Principles on Business and Human Rights. And I would hope that if there is a scheme developed in Australia, that it would move to look at a risk assessment model, that within a due diligence framework, entities would be required to identify, report, mitigate, address risks of exploitation in their supply chain. So that's one thing, and that's important. But there's something else, and this is the question I want to ask you, because I don't understand this. This legislative scheme, like the one in the UK, will not include punitive measures. So there will be no penalty for non-compliance. So my question is, why? Why not? You know, what we are looking at is an environment where slavery, forced labour, human trafficking have catastrophic consequences on the humanity and the dignity of human beings. Why not include a clause that would address failure to comply with a statutory provision? I don't understand why not. The explanations that we see don't really seem to answer the question. They say we don't want to discourage business from reporting what they have to report under this.
Well, the other thing, and forgive me for jumping in here, is actual public sector accountability. Why should the public sector be beyond reporting on its own supply chain? Yet the UK Modern Slavery Act, it carves itself out of reporting on this. If the state is going out preaching the law to multinational corporations, then it should abide by its own laws. And these laws on disclosure, very much like the Obama executive order in the US, should apply to in the context of the Modern Slavery Act as well. So I think that's a conversation that needs to happen in Australia. And sorry, in the interest of time.
I agree with that, but
Yep.
I just do want to ask,
Yep.
Either now or later, can you let me know what you think about this issue of no penalty for not compliance, given the context is the gravest of human rights abuses affecting vulnerable men, women and children throughout the world. This scheme does not include public procurement either.
Yep.
Yeah, actually, that's a really interesting issue, Archana.
Yeah.
One of the areas, certainly, I think one of the impacts of the Modern Slavery Act, but also just the increased attention that slavery as an issue is receiving globally, of which I think the MSA is one part of the trend. And as you say, it is a journey, I think, including for our own clients and for ourselves as organisations. But we are certainly advising more and more in the context of transactions on human rights due diligence and modern slavery due diligence. I'm aware of at least one example of a client aborting on a deal in situations where slavery was detected within not just the supply chain but possibly the operations, and it was a country where there was an obligation for government to procure only from companies with supply chains free of slavery, and in that situation, so much of the business was dependent on government contracting that it was a real sustainability issue just as far as viability of the organisation and the commercial interest was concerned. So that was, in one sense, an easy decision for the client, but it came from exercising caution in relation to that kind of diligence.
I think it's really interesting to note that the French law, the devoir de vigilance, actually has very stringent penalties for non-compliance. And there's a Dutch law as well, which is actually focused on child labour. There is a Swiss bill currently going through, which is hopefully going to go through sometime soon, but it has met very strong corporate opposition. And the Swiss bill is quite interesting because it provides access to remedy to those who've been violated within the context of supply chains, but it also reverses the burden of proof. So it's up to the companies to prove that they didn't actually violate the rights of vulnerable people. So there are a lot of models out there, and they're all at varying levels. So my question to you, and perhaps Michael, you can have a first stab at this, is could we think about a global standard? And instead of a patchwork of legislation where the benchmark is set there, and then there, should we be aiming for something a lot more rigorous globally?
Maybe a very brief response to your criticisms will help educate this response, because everything that you've hit on has actually been picked up on in parliamentary committees as criticism of the Modern Slavery Act. I think you gave it some slack by saying it's only 2 years old. It's an imperfect beast. I think I'm not a betting man. I don't think you're allowed to bet under Hong Kong rules, so I'm not going to place a bet on it. But I'm almost certain that the evolution of this act will be quite swift, and may address the points on no central database of reporting companies and their statements has been proposed. Public authorities are to be included. This is all proposed by Baroness Young, the second attempt she's been making to bring a private member's bill, and also the discussions have addressed inadequate reporting. So everything that you've hit on, the politicians, they have been considered. So when we're talking about a global standard, at the very least, I'd like to think of the global standard being the Modern Slavery Act 5 years down the line, which I'd like to think is a more developed beast. We wait to see. But I think it's clear that if the legislators in the UK are already agitating to have something more teeth added to the existing legislation, then it's obvious that change will come. As to a global standard, I think we should turn over to the politicians in the room and the UN diplomats.
On that note, Jennifer, I can ask you for a quick response, and I'd like to end with going back to Lowell very quickly.
Well, I'm interested in the idea of the Section 54 2.0, and I'm encouraged to think that do you think that might happen, and you'd have more sense of whether that is a possibility.
He's less cynical than the two of us, I think.
Yeah. But a global standard, well, the question is what standard, obviously, and what if it's the lowest common denominator? how can there be a global standard when there's so much inconsistency throughout the world? National regulatory schemes are so different. There are different legal systems. Some countries don't have legislation addressing human trafficking, forced labour and slavery. You know, how would a global standard work in that context? But perhaps looking at United Nations GPs, you know, is something that could be worth exploring, and you know that would certainly be an attractive model.
And Lowell, I'd like to put my last question to you so we can leave some time to questions. So given that we're sitting in Hong Kong, you have a lot of experience working on Hong Kong and China issues. Can there be a legislation like this in Hong Kong? Bearing in mind we have no anti-trafficking legislation.
Yes, I think one of the first steps would be to work on the anti-forced labor, modern slavery kind of legislations first. I think this kind of corporate disclosure is kind of a higher standard comparing to just illegalizing forced labor, which is not completely applicable to Hong Kong at this moment. So if we can take a big step forward, I'd like to see both the illegalization of forced labor, not just limiting to prostitution, but also to forced labor as in general. But also on the corporate side to encourage them in some sort of ways to disclose about their practices eradicating forced labor in their supply chains and operations.
Archana, one of the interesting areas in Hong Kong in particular has been the comply or explain provisions in relation to reporting by listed companies in Hong Kong, which sometimes run ahead quite some way from legislative introduction. So that may also be the angle that in the end you could see in Hong Kong rather than necessarily legislative change.
Absolutely. We have about 4 minutes. So can I take some questions from the floor? Any questions? Yeah, we have a question.
Thank you. I'm Aditi and I work for Adidas, and one of our submissions to the Australian Parliamentary Inquiry was a concern over these parallel legislative requirements. So it's interesting, Archana, that you bring up a global standard because, I mean, our resources will then now be spent on responding to France's Act, to Australia, to the UK, and I just want to understand if anybody on the panel has faced concerns from other corporates, and if so, you know, what are the other corporates saying in terms of responding to, because this can create duplication, multiple varied approaches. So are we alone in our concern? Anything that you've heard from the others?
You're absolutely not alone, and this has been a driving factor in the some of the framing in the response in the discussion paper by Minister Keenan, that recognising that it could cause difficulty for companies to be required to report in multiple different formats throughout the world. You know, that being said, it's important that the standard that's agreed is an appropriate standard. But the Minister specifically addressed that point in the discussion paper. And if I could just say, if you're interested in looking at the discussion paper, it's on the Attorney General's website, and they are calling for submissions by the 20th of October.
On the point of papers, you'll have each seen on your seats today, there's a short white paper co-authored by Liberty Asia and Clifford, which gives you a quick sort of roundup of the different pieces of legislation globally and our thoughts on a global standard. Any other questions I can take?
In the Australian context, so far, I think it's true to say that there's not significant buy-in from business. There was 205 submissions to the Modern Slavery Inquiry. Only 40 of them were business related, and only 20 of that 40 had that global income of more than 100 million Australian. So we'll see how this develops through the next consultation process. But the government won't proceed unless there is widespread business buy-in and community support. So the intention to establish a Modern Slavery Act in Australia is dependent really on the enthusiasm of business, civil society. So it's an in-principle statement at this stage only.
So So it appears that there are no further questions. I think everyone's desperate for a break. So I'll wrap up in 10 seconds, and that'll make me in time, which I'm really proud of. One thing about modern-day slavery is that slavery doesn't look at boundaries. Slavery defies boundaries. It goes beyond jurisdictions. In our response to slavery, we are often limited by jurisdictions. So maybe there is a case to be made for a global standard so that we're not working with a patchwork of measures that vary depending on the appetite of business or how politically committed governments are to this issue. I guess I come back to the point that whether it is a national standard, a regional standard, or an international standard, it must always be constructed on the paradigm that risk to people is ultimately risk to business. So with that, can I ask you to join me in thanking the panel? Thank you very much.